We're live at the closing arguments of the Fani Willis, Nathan Wade debacle going on. We're only minutes away from hearing the closing arguments. I hope you guys join me in watching this, and I'm going to put it up live, and we will talk over chat during the closing arguments so we can talk and see what's going on. And that's what we'll do while we're listening to this. Just you can leave your opinions. And there's a lot of other streamers out there that are going live for this today, so they can hear themselves what's going on. So I hope you join me in watching this. So once it comes on, then I'm going to put this up, and we're going to leave it play while we're watching, and we'll see what's going to happen today. Hopefully the judge will disqualify him, and then the Bar Association will take over and take their law license away. But we're going to have to see what happens, you know. But if you guys aren't used to what's going on here, there's been so much going on. Let me find here and I got this funny thing for you. So I found this picture today on X, and it was hilarious. Check a look at this. This is it's the funniest thing I've seen. So I thought I had to share that with you guys. I'm not sure what kind of a delay I have, so this is the funniest thing I've seen in a long time. But while we're waiting for this, I'm going to do something real quick. I went through the new hearing with Terrence Bradley the other day, and it's about a little bit of about 3 minutes long. I hope we have enough time to get this out there, but I want you to hear how many times he could not recall something. So I'm going to play this real quick. Oh, never mind. We're going to go live right now. So here we go.
Blitz for Mr. Julie and Mr. Julie Wade.
All right, on behalf of Mr. Giuliani.
Alan Stotson, on behalf of Mayor Giuliani, who waives his presence.
Thank you. On behalf of Mr. Meadows.
Your Honor, Jim Durham, on behalf of Mr. Meadows, he waives his appearance.
On behalf of Mr. Clark.
Harry McDougall, Your Honor, Mr. Clark waives his appearance.
On behalf of Mr. Roman.
Good morning, Judge Ashley Merchant and John Merchant on behalf of Mr. Roman, and he waives.
On behalf of Mr. Schaefer.
Good morning. Good afternoon, Your Honor. Craig Gillen, Anthony Lake, and Holly Pearson on behalf of David Schaefer, and he waives his presence.
On behalf of Mr. Floyd. Do we have anyone joining us on Zoom on behalf of Mr. Floyd? All right. Well, seeing as counsel had previously attended the prior hearings and this one has been noticed, I'll find that they've waived their appearance for argument today. Anyone on behalf of Ms. Latham?
Good afternoon, Your Honor. Bill Cromwell on behalf of Ms. Latham. She waives her presence.
All right. Thank you, Mr. Cromwell. All right. So I had been informed by counsel collectively for the defendants that they were requesting a total of an hour and a half for argument to be divided amongst themselves as they've already agreed. And so to effectuate that, I'll have the time queued up, and we'll start the clock running, and y'all can see fit to divide that as you would like. And obviously I've allowed the same amount of time for the state as well. Before we get into that, I believe there may have been a few things just to clean up as part of the record, specifically since we last convened. Counsel on behalf of Mr. Roman had submitted a Defense Exhibit 39, and if there are any objections that wanted to be placed on the record on behalf of the state, we can do that now. But at a minimum, I think the intention was that I would be admitting that collectively as an exhibit, if nothing else, just for appellate purposes for the record. Mr. Abadi, anything the state wants to add as it relates to Exhibit 39?
No objection from the state.
I have a copy for the court reporter. I printed a copy out and then I sent it along.
All right. If you've got that marked and stamped, we'll provide that to the court reporter. All right. And then, as I'd indicated as well on Tuesday, both parties since the close of the evidence on the 16th had followed up. Now I think both sides have made requests to reopen the evidence. On behalf of the defense, there were some issues with cell phone records, and the state has found an additional witness that they would like to present. And the instruction I provided on Tuesday was that for today, I think we've reached the point where I'd like to hear more of how some of the legal arguments apply to what has already been presented. And it may already be possible for me to make a decision without those needing to be material to that decision. So that's why we're here today. I wanted to make sure we held this time because it is a bit of a logistical challenge to get everyone in a room together. But recognizing that, again, in the interest of efficiency, if both parties want to reserve part of their time to argue as if those proffered exhibits have been admitted, feel free to make whatever arguments you would like.
All right, so you can see that the judge is providing instructions to both sides in the Fani Willis misconduct case. This is the perfect time to step away for a 2-minute break because those opening statements have not yet started. We will be right back.
Okay, once my video gets back up here, and see why my video is not up. And see what's going on here. Okay, don't understand what's going on here, but I'm thinking you guys can hear me, but I'm definitely not seeing myself. And I'm going to try to get this fixed pretty quick here. So it makes no sense why my camera's not working right now. So that's working, but I'm not working for some reason. And I've got to try to get this figured out here. Hold on one second while I get messing with this and try to get it to work. While I let you watch that for a minute while I do this. Oh, this is annoying me. We're going to watch this for a little bit until I can get this figured out.
We're expecting the closing statements in the Fani Willis case to get underway at any moment. Let's pot up the sound and listen in.
We do have an oral proffer. We can file it, and we can supplement the record and file it for the court's consideration. But literally,
Right.
hot off the press.
Sure.
As we printed it out and drove down to the court.
Okay. All right. Well, Mr. Cromwell, is there anything you wanted to add to that?
No, Your Honor.
Okay. Mr. Abadi, anything you want to add to that?
I don't know what it is, so I don't know how to add to it. No.
All right. Just anything on a procedural perspective.
I mean, from a procedural perspective, I would submit to the court, as you said multiple times, evidence is closed. This is beyond the scope of Your Honor's ruling on Tuesday. Feels like but Tuesday. So I guess we'd object at this point and go from there.
Okay. All right. Anything else by way of housekeeping, Mr. Sato?
Apparently the state filed 2 supplemental exhibits, number 2 and number 3, about 15 minutes ago. So to the extent that they can come in and use those in their proffer, talking about the same notice requirement, we actually did this document.
Understood.
So as it relates to that, Your Honor, I believe you were very clear on Tuesday as well that in the proffers, we could argue rebuttal evidence as it relates to the evidence that was submitted by defense counsel after the evidence was closed. And that's merely what it is. It's rebuttal evidence as it relates to the cell phone records or analysis that was done by the non-expert filed by Mr. Seda.
All right. Mr. Gillen.
As it relates to the proffered evidence, our proffered evidence would be in direct rebuttal to testimony given in the courtroom, particularly by Mr. Bradley. So we would have a direct rebuttal of that. That's what our proffer will be. I understand the court's ruling. Just want to put that on the record.
Just so we know the context of it. Is that similar for Mr. Cromwell as well?
It is.
It just solely relates to Mr. Bradley's testimony?
It does.
Okay. All right.
Excuse me?
All right, noted. Anything else then?
Your Honor, the proffered evidence is basically would corroborate what been admitted in evidence is Exhibit 39, the chronological text.
Okay. All right. Then if there is nothing else, I'll turn it over to Ms. Merchant to begin on behalf of the defense.
Sorry, Judge. Unfortunately, you're
Okay.
stuck with me today.
Understood.
May it please the court, Your Honor, John Merchant on behalf of Mr. Roman. Just by way of roadmap to give you some idea about the allocation of time and what I'm going to be covering. I've been charged with talking to Your Honor about the conflict issue and the appearance of a conflict and what we believe the evidence to show on that issue. Mr. Sadow, Mr. Gillen will be talking more about the forensic misconduct piece of it. Ms. Willis's church speech, statements made to the media, fraud on the court, frankly, and the book that she gave several interviews for. So I won't be discussing any of those issues. So if you like to ask me, certainly I can try to address them, but that's going to be the focus of their presentation. And then towards the end, other folks may have issue-specific type arguments, either in follow-up to mine or the forensic misconduct. But those are the two lanes that we're going to be covering, but I'm going to do the conflict piece of it for you. And on that issue, Your Honor, this is a matter of first impression in Georgia. I can't find a single case that's been published by the Court of Appeals or the Supreme Court that is based on these facts. There are, of course, a number of different appellate court cases that deal with conflict-related issues, and more importantly, appearance of conflict-related issues. And some of those are based in state law. Some of them are based on the ethical rules that govern lawyers. Some of them are based upon the Sixth Amendment right to due process that's implicit in all of what we're doing here today. I want to remind the court that we're here today on this motion to disqualify DA Willis and her office because of her judgment, frankly. She is supposed to be disinterested under the Sixth Amendment, and she's anything but that. The fact that these proceedings have taken this long and through the convoluted way we've made it here today explain that. So as I present my arguments, I want the court to understand that this court represents the guardrails for the Sixth Amendment in this context, and Ms. Willis has already been disqualified once. So I would encourage the court to remember what Judge McBurney did in his order disqualifying. The same argument was made in that case as to whether or not there needs to be an actual conflict of interest or whether or not the appearance of a conflict of interest might be sufficient under the facts. I want to make clear to the court that the law in Georgia suggests and is very clear that we can demonstrate an appearance of a conflict of interest, and that is sufficient. I'm going to be candid with the court. There is a Supreme Court decision from 1996, Lambie State, and then there are two Court of Appeal decisions after that deal, frankly, in some dicta that suggests that an actual conflict is required. But the Supreme Court of Georgia, since those decisions came down, has made quite clear that the appearance of a conflict standard still applies. And the reason that's important is I think under the Sixth Amendment, which is where we're at, in order to preserve the defendant's rights under that under that provision and under corollary provisions of Georgia law, you've got to consider the appearance of a conflict. And the reason why the appearance of a conflict is so prescient here is because if this court allows this kind of behavior to go on and allows DAs across the state by its order to engage in these kinds of activities, the entire public confidence in the system will be shot. And the integrity of the system will be undermined. And so with those sort of public policy and constitutional principles, I wanted to turn to the law in Georgia on disqualification. And Your Honor, I'm gonna give you the law, and then I'm gonna talk about the facts and how they apply to the law at the end. If you want to talk about the facts earlier, jump right in, and I'll be happy to do that. I'm sure Your Honor is very well prepared and probably knows all the law that I'm going to cite to you. But to give the skeleton outline, the original seminal case that deals with conflict of interest from the Georgia Supreme Court is Williams v. State. That's 258 Georgia 305, and there are basically two methods by which you can disqualify a district attorney. One of them is a conflict of interest, and I'll suggest to the court that doesn't mean an actual conflict. That could mean an appearance of conflict as well, and then forensic misconduct. Importantly, in the Williams case, though, in footnote 4, and I think this is important for the court's analysis about the facts and which box it fits into, the court said there was no clear demarcation line between conflict of interest and forensic misconduct, and a given ground for disqualification of the prosecutor might be classifiable as either. And I think that's important because we have facts that fit in both boxes. So if a state stands up and says, well, there's no actual conflict here, Judge, that doesn't mean necessarily that it doesn't apply to the forensic misconduct. Typically, forensic misconduct relates to statements of the prosecutor designed to impugn the character of the defendant before trial and to affect the jury pool, which we have here, which I'm not going to discuss. But the facts that we have here very much relate to that issue, and there's crossover. Importantly, and I think this is important for the court's consideration of what effect the court's ruling may have, is if you deny this motion, there's a good chance, if it's reversed, that we would be granted a new trial. So that means we're going to have to do this all over again. In amusement sales versus state 316 Georgia Appellate 727, that's a case that cites Whitworth, which is physical precedent only. The court said, if the assigned prosecutor has acquired a personal interest or stake in the conviction, the trial court abuses its discretion in denying a motion to disqualify him, and the defendant is entitled to a new trial, even without a showing of prejudice. So that means if we show the court today, and I think we have through the proceedings today and before, that Ms. Willis has developed a very personal interest in this case, and Your Honor denies this motion, we're coming back all over again. This motion, we're coming back all over again if the appellate court say you were wrong.
So what is that personal interest?
So the personal interest can be, there's no definition of that under Georgia law. And it could be a personal financial interest. It could be a personal interest related to bias against a particular defendant, which sort of falls into the forensic misconduct box. But we have here a very personal financial interest that's been laid out in terms of money received by Ms. Willis as a result of the scheme that she set up. But to get to the issue of the personal interest in the context of an appearance, I think that's important. I do want to suggest to the court that there are a number of cases that post-date this actual conflict of interest language that's suggested in some of the cases from the 90s that you have to pay attention to what this looks like to the public. And I agree with all of the law, and I'm sure the state's going to stand up here and say it can't be a speculative or a conjectural type of personal interest. We don't have that here. We have something very concrete. And as Judge McBurney put it, actual and palpable, not speculative and remote. That's exactly what we have here. We've demonstrated through the testimony of the witnesses, some of whom impeached themselves, that we have a very personal interest. In the seminal United States court case that deals with prosecutorial impropriety is Young v. U.S. That's a 481 U.S. 787 case. In that case, it's the opportunity for conflicts to arise that created at least the appearance of impropriety. And that's the case that requires that the prosecutor be disinterested. Since a scheme injecting a personal interest, financial or otherwise, into the enforcement process may bring irrelevant and impermissible factors into the prosecutorial decision. Now, there are a number of Georgia cases that sort of repeat that theme. Reeves v. State, 231, Georgia Appellate 22, that's a 1998 case, stated a potential conflict of interest existed and the appearance of impropriety existed. Davenport v. State, 157, Georgia Appellate 704, that's a 1981 case. That was decided 7 years before Williams. When there is at least the appearance of impropriety, a defendant is denied fundamental fairness in the state's prosecution of the charges against him or her. There are also rules that govern prosecutors. Lawyers in general are bound to preserve and avoid even the appearance of impropriety. That's Brown v. State, 256, Georgia Appellate 603, 202, 2002. Head v. State. A prosecutor's close personal relationship with the victim in a case may create at least the appearance of a prosecution unfairly based on private interest rather than one properly based on vindication of public interest. ABA Criminal Justice Standards for the Prosecution Function, Standard 3.1.2c. A prosecutor should avoid appearance of impropriety in performing the prosecution function. 3-1.7f. The prosecutor should not permit the prosecutor's professional judgment or obligations to be affected by the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. So the rules that govern her in her own profession say that this is wrong because she's developed a financial interest in this case. And at the very least, created the appearance of unfairness towards these defendants by setting up a relationship, a prosecutorial relationship with her boyfriend that she'd been dating for 2 years, according to the testimony. So before I move, Your Honor, to the specific facts, you asked, what's personal interest, and I think, frankly, as I was trying to figure this out, I think you know it when you see it. It's just like in the concurrence in Jacobellis versus State of Ohio, Supreme Court case from 1964, Justice Stewart, in his concurrent opinion, said, "I know it when I see it," talking about obscenity. I think you know it when you see it. I think there's enough facts in front of you that you know it when you see it. And so I think that the governing principle helps enlighten some of the facts here. And also, I think it's not just financial. And McLaughlin v. State, I think the court's very familiar with that case, 295, Georgia 609, 2014. The Supreme Court essentially said that because the acting DA had become a witness in the case and developed a personal interest in the case due to his daughter's relationship with the victim, that he was disqualified. And because he was disqualified, his entire office was disqualified. So turning to the facts of the case, Your Honor, I think I've got, my role is 20 minutes, so I've got about 8 minutes left. So why the relationship, why did we spend so much time on a relationship between these two people? We frankly couldn't care less if they had a personal relationship outside of work. That is not what the issue is here. The issue is that they began this relationship in 2019. They were dating for 2 years. And then she awarded him a contract where public money, either from Fulton County or the state of Georgia, ended up in his pockets. That decision alone was improper. But what's even more improper is that then she and he used that money to go on personal vacations and trips. If Your Honor will remember, Exhibits 9, 11, and 12 dealt with the expenditures by Wade on trips. If you do the math on that, if you look at what he spent, and then you look at the testimony about what was paid back by Willis, because of the cash reimbursement theory, I'll talk about in a second. But if you do the math on what he actually paid for and what they testified she paid back in cash, you still have over $9,200. $9,200 and $9,247 to be exact is the amount of money they cannot account for in their testimony. And as Your Honor will remember, there was no mention of cash in Mr. Wade's affidavit when the best and first opportunity to raise that issue would have come up is when the state filed their response in his affidavit. That is nowhere to be found in there. The first time we heard about cash was here in this courtroom. And so I think she's received a personal financial benefit of over $9,200 in this case that she can't account for and the state can't account for. And the reason we can't account for it is because they came up with a cash theory. Cash theory only
Before we
raises.
get into that, let me ask you this. Let's say let's say the theory wasn't even there that they had paid it back or that there'd been any exchange. Should there first be a consideration of a materiality requirement?
No.
Have you seen that in this jurisdiction it's not in this jurisdiction. Have you seen that in any other jurisdiction?
I haven't seen that, Judge. And if it was $6, that would still be improper.
Would it be improper where it's a per se disqualification if someone, buys their boss a stick of gum? Is that per se disqualifying because there's no materiality requirement?
Well, no, I don't disagree that it may not meet a materiality requirement, but it's a personal benefit. I won't say that giving me a pack of gum is just justification for disqualifying a district attorney. I think that's part of the issue, Judge. I think it's a fact-based inquiry by you.
So there's a continuum involved here.
Yeah, but I think the continuum involves you looking at whether or not, in the grand scheme of things, it violates the Constitution, and whether or not there's an appearance of a conflict, and the appearance suggests that she actually received a benefit, and we know that she did. They admitted it. We don't have to speculate about that. They said that she said she got a benefit, and she said she paid back certain amounts. In that regard, Your Honor, I don't know, would $100 be enough? Would $200 be enough? I think you have to look at it globally and consider all of the witnesses, consider all of the facts, consider the credibility of the witnesses. Frankly, I mean, Your Honor sat here and watched everybody, so I haven't spent a lot of time going into the specific testimony because Your Honor is well aware of it. But you get to evaluate the credibility of the witnesses as a fact finder. And, just
from a legal perspective, though, you're saying we can't just say dollar amount, look no further. There has to be a totality of the circumstances analysis.
I think it's fact specific, Judge. I don't really want you to pin me down on that because there's no law on it. I can't give you a straight answer because I haven't seen anything like that. And I think if we build a materiality requirement into the case law, then you're down a slippery slope then, because then it's going to be the appellate courts are going to be deciding, well, is $50 enough? Is $100 enough? So I think it's not necessarily the amount of the money. It's the fact that she received it, and it's not insignificant. And I don't think your order has to say because she received $9,200, she's disqualified. I think if we go back to the 20,000-foot level, what's the appearance here? Is this fairness to the defendants? Does it appear that she is interested in this prosecution, or does it appear that she's disinterested? She took the stand. You can tell she's not a disinterested person when it comes to this proceeding, but we also argue she's not a disinterested person when it comes to the prosecution as a whole.
You're live inside this courtroom. Welcome back to Live Now from Fox. We're going to head back inside this Georgia courtroom and take a listen as the defenses continue to deliver its closing arguments in the Fani Willis misconduct case. Let's listen in.
Jury room than I did. So that's what they're worried about. And the reason why it's important for the financial piece, Judge, is it's how the money ended up going back to her. She put her boyfriend in the spot, paid him, and then reaped the benefits from it. That she created the system and then didn't tell anybody about it. She didn't even tell her dad about it. So I think if in the grand scheme of things, if you're looking at the totality of the facts, and I've got to sit down here in about 2 minutes to make room for my co-counsel. If you look at it, everything put together, judges, they did this, they knew it was wrong, they hid it, and even when they were called out on it, they tried to create an excuse for it by saying it happened after the fact. We know now from the testimony, Ms. Yurdy confirmed that Mr. Bradley, his text messages were accurate, not his court testimony, but that fact was accurate. The motion is accurate. And so also, I do want to point out there's no paper trail here for the cash. I know that this was I know she and her father both testified that they kept cash on hand, which, I mean, keeping cash on hand in and of itself is not a problem. When you're a public official and you're required to keep track of gifts that you receive, then you need to keep track of it. But there's no paper trail. There's no deposit history. There's no withdrawal history. There's no receipts, none of that. So even assuming their testimony could be credible, and we don't think that it is, you still don't have enough information to track all that money that she received. And this is just what
But
we
does
know
the
about.
lack of evidence fall on the state? Does the lack of evidence fall on the state? Isn't that where burdens come in?
Yeah, yes, I think they had an obligation to tell Your Honor, hey, this is where the money went. And they certainly had the ability to do that if they could do it. Since they didn't do it, we have to assume they can't. And if they can't, I just want to remind the court of a very important piece of testimony from Ms. Willis that I think goes to credibility of all of the officers of the court who testified. She met with Wade and they developed in 10 minutes after talking about the financial piece, I believe, this cash theory that could not be rebutted. We have no ability to do that. They did, and they chose not to do it. So with that, Your Honor, unless Your Honor has more questions for me, I'm going to sit down and turn the podium over to my distinguished colleague, Mr. Sadow.
Thank you, Mr. Merchant.
All right, so we are going to step away for a brief 2-minute break because we do want to bring you the co-counsel's arguments in its entirety. We'll be right back. Welcome back to Live Now from Fox as the defense continues to deliver their closing arguments in the Fani Willis case. This is the attorney who is representing former President Donald Trump. Let's listen in.
Church members, or anyone for that matter, that the reason that Mr. Wade was being challenged was not because he was black, had nothing to do with race. It had to do with the relationship that had been alleged and later admitted to by Ms. Merchant. Ms. Willis took full opportunity to prejudice the defendants and then comes along later in a pleading and says it wasn't designed or intended to be at the defendants at all or the defense counsel, which with all due respect is just nonsense. The purpose of that was to get public sympathy, public empathy for what Ms. Merchant had already alleged in her motion. Now, that was a violation of the professional rules of conduct. It was a violation of 3.8G. There's no question about it. It wasn't in response to anything that was said. It was a public statement, extrajudicial, for the purpose of making a comment upon the defendants.
It would be in response to a motion that was filed.
But it wasn't filed in a response, in a pleading. It was filed in response to a motion. And the motion were allegations made. If Ms. Willis wanted to respond at that point, she could have said the facts of the matter. Instead, she misstated what the situation was, took advantage of the opportunity, an ethical violation. And the ethical violation makes it clear that you must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Can you think of anything more that would heighten public condemnation of the defendants than alleging that defense counsel and the defendants were making their motion based on race and religion? That's as bad as it gets in Fulton County, with all due respect. That's exactly what Ms. Willis wanted done. And remember, the state still had not responded. So then what we get from the state is we get an affidavit filed as part of their response. And that affidavit says specifically, and the affidavit is Mr. Wade, says specifically in paragraph 26 and 27 that the relationship did not begin until 2022. It acknowledges the relationship and says it didn't begin until 2022. And the pleading that's filed, the state's pleading in response, indicates not exactly that, but it says there was no relationship as of November 1 of 2021, and that's on page 7. So now we know that timing is the issue because Ms. Merchant made it clear that we alleged and had evidence that indicated the timing was before Mr. Wade was hired, not after. So the state now has filed an affidavit and a pleading that claims post-hiring into 2022. And then Mr. Wade will testify to the same thing under oath. Now, Ms. Yerty says it began in 2019. Why would she know? Well, she would know because she was a former friend. I know the state's going to get up here and say, you can't believe, essentially what they're going to say is you can't believe any defense witness. Mr. Wade, because they're defense witnesses. And only people that would tell the truth would be Wade and Willis. I suggest to you that that's not accurate. I suggest that the testimony that Mr. Wade gave and Ms. Willis gave, and I'm specifically dealing now with the timing issue, without getting into anything else, that brought forth a true concern about their truthfulness and being what is required of a lawyer in this state, which is candor toward the tribunal. And that's 3.3 of the professional rules. Specifically, small a1, make a false statement of material fact or law to a tribunal. So that's, as I posited to the court, that's the second ethical violation. And then you also have 8.4 of the professional rules, it says it's a violation of the Georgia rules of professional conduct for a lawyer to, and that's A4, engage in a professional conduct involving dishonesty, fraud, deceit, or misrepresentation. Now, do you have to find that Wade and Willis lied? No. What you need to be able to find is that there is a concern, a legitimate concern based on the evidence in this case about their truthfulness. A legitimate concern about the truthfulness, which equates to an appearance of impropriety. Because once you have the appearance of impropriety under forensic misconduct, the law in Georgia is clear, that's enough to disqualify. So why should you find there's a concern with their truthfulness? ERT is the first one. You have that testimony. But then we go to what is the most obvious indication that Willis and Wade were not truthful on the point of timing, and that's Bradley. Defense Exhibit 26 came into evidence. Defense Exhibit 26 comes in and says, and you know I went into this the last hearing. It says that on January the 5th, 2024, at approximately 9:49 a.m., there's text messages that are exchanged between Ms. Merchant and Mr. Bradley. And the text messages go like, just date, and that's from Ms. Merchant. Ms. Merchant says, do you think it started before she hired him? Bradley, who we now know from Defense Exhibit 39, has been texting with Ms. Merchant for a number of months. This is not the first time. This is months within the communications between the two. Mr. Bradley says, absolutely. Now, absolutely is not a speculative word. That's not speculation. That's a definitive statement. And Bradley then unprompted as this, and unprompted is important. It started when she left the DA's office and was a judge in South Fulton. It goes on, Ms. Merchant says, she liked it started when she left the DA's office with the appropriate emoji or whatever one would call it to say it was liked. And then Mr. Bradley say they met at the municipal court CLE conference. Again, unprompted. He's now definitively telling Ms. Merchant when this relationship started. Ms. Merchant says, that's what I figured when he was married. And then Ms. Merchant says, and we're now talking about a couple hours later, she texts and says, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And Mr. Bradley responds, no, municipal court. Thank you. Doesn't say it didn't start then. He doesn't suggest that she's wrong other than magistrate court municipal. Now we have that and it's in evidence. And what does Bradley do? He knows that he's put himself in a position that if he testifies truthfully on the witness stand, Your Honor is in a position to be able to find, if you choose to, that both Willis and Wade lied. So what does Bradley do? Look, you were an assistant U.S. attorney. You know how this works when you have witnesses in this situation. Mr. Bradley did everything he could possibly do to evade answering questions. No recollection, couldn't remember, it was speculation. Anything he could possibly say that would cause, Your Honor, not to believe that Bradley knew when this relationship started. I suggest they were clear-cut lies, and the truth is in Defense Exhibit 26.
And so if we take that view, that he thoroughly impeached himself, that he did not give truthful conduct, what's left standing? Generally, you would see someone who's impeached, perhaps we have some kind of core that you could point back to and say, that's the time he was telling the truth. In these text messages, is it ever definitively shown how he knew this and that he actually did know it, other than in just a assertion outright, absolutely. Usually, if a state has a witness that goes sideways, they've got them locked in. They've sat down with a detective, got a full statement. We don't have that here.
But what you have is a text message, which is a prior statement of Bradley that he did on his own, that was not given to him by someone else. The only thing that the court has just noted is, how do we know he wasn't speculating? Because you don't have to accept the fact that he wasn't speculating. The cases that I provided, I think by email yesterday, the first dealing with that, you can disbelieve that testimony and draw a negative inference. That's the Ferguson case. On Lee, the other case, you can simply take the prior inconsistent statement as substantive evidence. It has the same value. And that's what I'm asking you to do, to take what was the unprompted statement in Defense Exhibit 26 of Bradley and take that on its face value, that is an indication that Bradley in fact knew and had said he did. If you accept that, you have to have concerns about the truthfulness of Willis and Wade on the timing issue.
And I don't know if this is something maybe one of your co-counsel were going to address as well. We heard about kind of the law that applies, how we're outside kind of the orbit of the core of cases we're used to dealing with here, where it deals with side switching or where someone is in the relationship, the client relationship. The proposition you're putting forward now is that if a representative of the state, a lead prosecutor, the district attorney themselves, says something that's untruthful on the record, that is something that immediately has to be proactively policed by the trial court. Is basically what I'm getting at is, where in the law do we find the remedy to an untruthful statement? Generally, we send you down the street to the bar, right?
And that's why I gave you the cases of Registe and Edwards yesterday. While those aren't prosecutorial cases or dealing with prosecutors, they deal with counsel. And in both those cases, the trial judge found ethical violations on the part of defense counsel, or potential ethical violations, went through the ethical violations and said, based on that, you're disqualified. You cannot be the attorney of record in this case. What's good for the goose is good for the gander. If defense counsel can be kicked off of a case because of ethical violations, I suggest the same thing can happen for prosecutors when the ethical violations deal with truthfulness, candor to the court, extrajudicial statements. Those are the things that this court can rely upon and say, based on those, again, I find an appearance of impropriety.
Where would be the limiting principle? The district attorney signs every indictment assigned to this courtroom.
No.
Does that mean she's off every case?
No, it would be when the...
If I found that she's untruthful, is that what you're kind of suggesting, though?
You don't have to find, again, I'm not saying you have to find she was untruthful or that Wade was untruthful. You don't have to make a finding of fact that they lied. All you have to do is make a finding of fact that you have genuine, legitimate concerns about their credibility, about their truthfulness. And once you find that, then you can apply Registe and Edwards.
Well, but it's the same principle, though. If I have genuine concerns about her truthfulness on a particular occasion, how do those not spill over into every criminal case a district attorney brings?
Well, it's because she testified under oath, and so did Mr. Wade. They didn't have to testify falsely. They could have testified truthfully. They could have indicated that the relationship, the timing was in fact before Mr. Wade was hired. They chose not to. And in that sense, that dishonesty, that constitutes a violation of their ethical responsibilities. This is not signing an indictment. This is not filing a pleading in which both sides have their own positions. This is a requirement that every witness has to tell the truth under oath. And if they don't tell the truth under oath, or there's a significant concern about their credibility, then they're violating their ethical rules. And as anyone will tell you, as Your Honor already knew from when you were a prosecutor, prosecutors are held to a higher standard. They're the ones that are supposed to be seeking justice. They don't have a particular, they're supposed to be disinterested. When you have the lead prosecutor and the DA giving, what I suggest to you is untruthful testimony based on what Yerty has said, based on what Bradley said in his text, based on the whole way it was presented to you. Bradley didn't want to testify. He first came up with his attorney-client privilege thing on that. And Your Honor was, fortunately, went into that. And then when Bradley knew he had to testify about it, you saw what happened. You can draw the inference, as I've suggested on Bradley, that what he said in the text message, Defense Exhibit 26, is true. The relationship, in fact, started prior to November 1st of 2021. The ERT says that. And now, without getting into any detail, the cell phone records. The cell phone records show that during that period of time from, let's say, April 1 of 2021 to November 30th of 2021, that there was a considerable number, 35 or more occasions where it appeared that, based on the records, that Mr. Wade was down in the area where Miss Willis was staying in Yerty's apartment. But more important is there are two occasions, and the state has not challenged those. There are two occasions where the records reflect that it appears Mr. Wade spent the night at that apartment. The state may say, we don't accept that, but they didn't challenge it. And even when they brought forth what they brought forth today, supplemental 2 and 3, they didn't challenge it again. So what does that suggest? That's corroborating evidence of what Yerty had said, of what Bradley said in his text message. It's also impeachment evidence as to what Wade and Willis said about how many times.
Is that a significant, in terms of just the times? Didn't Mr. Wade testify that he was there at least 10 times during that time frame? You've now found 35.
Well, minimum of 35.
Okay.
But never overnight. He said he never spent overnight.
Put that to the side, though, just in terms of the fact that he did say he'd been over there, that he'd visited the place, and I would presume he wasn't obviously keeping a very good accounting of it, but that wasn't something that was entirely denied.
If you're asking me, do we win on the point that he said more than 10 or around 10 and we say 35, do we win on that point?
Sure.
No.
Okay.
It's not determined.
The overnight rate might raise some more concerns. Understood.
Yeah, it does. And that's the reason why we highlighted it in the affidavit of Mr. Middlestat, because that is suggestive that they were not being honest to the court. So then, how much time have I used? Have I?
I'm letting them use the hook. So suggestive, again, raising issues. I'm wondering about burden. Is it we're dealing with a preponderance standard?
We are dealing with a preponderance standard, and it's our burden.
Yeah.
No question about that.
So does suggestive get us there?
No, but it is corroborating evidence that we did put up. And that's what the purpose of the cell phone records. They corroborate what Yerty says. They corroborate what Bradley said in Defense Exhibit 26. And they impeach, to that extent, Wade and Willis's testimony. So if you find by a preponderance of the evidence, so I can finish this up, if you find by a preponderance of the evidence that what I call subset of forensic misconduct, ethical violations, has been shown, and that there is a significant and legitimate concern about the truthfulness of Wade and Willis, they're disqualified. Now, obviously, factual findings are yours, but the law allows you to do that. You don't have to do it through an actual conflict. That's the other side of the equation.
All right, so you are taking a listen as the defense is delivering closing arguments in the Fani Willis case right there. And you can see that the camera is panning to the judge as he is asking a question. We are going to step away for a brief 2-minute break, but after the break, we will continue to follow closing arguments in the Fani Willis misconduct case. We'll be back in 2 minutes.
when someone crosses the line on public comments is that Williams case. And it talks about there has to be an implication of saying the defendant, a particular defendant is guilty. And it even denied it, right? So have you found any case in Georgia where they actually said that a prosecutor had gone too far in their public comments? Does one exist?
Well, number one, thank goodness it doesn't happen often. Sadly, it's already happened here. Now, in Williams, the prosecutor had one response to an inquiry. The court found it was improper, but did not have this pattern. Now, it doesn't necessarily mean a comment about the quote guilt or innocence, although that was the pattern in Williams. It's the improper comments by a prosecutor. For example, in Williams, they
Welcome back into Live Now from Fox. Austin Westfall here in the anchor chair. We're going to get you back into the defense. They're doing their closing arguments in this case to disqualify Fani Willis. Let's keep listening.
And how prophetic that was. When Williams cites that case in that law school article, they talk about an awful lot more than simply the comments about specific guilt or references to guilt. What you have here, Your Honor, is a comment, and we can't look at it doesn't apply only if a prosecutor said, I think the defendant is guilty in my mind. No. It's more pernicious than that. What we have here is someone who sat down and drew up a plan for two reasons. And what she did reminds me of what the court in STV, Texas talks about, and that is that pretrial can create major problems for a defendant, indeed more harmful than publicity during a trial, for it may set the community opinion as to guilt or innocence. That's what we have here. That's exactly what we have. And the court in Estes talks about the power of the television camera. So what do we have, and what did this prosecutor do? What she chose to do is sort of what was criticized by the Supreme Court in Shepard v. Maxwell. Legal trials are not like elections to be won through the use of meeting halls, the radio, or the newspaper. That's exactly what we have here. What we have is a deflection. What this is all about is more insidious than just making the comments that she's made. It's a deflection. What she chose to do was to say, okay, I have done my best to hide the relationship with Nathan Wade. And Nathan Wade has done his very best by filing false documents in his divorce case to hide his relationship with Miss Willis. Now, and so what did they do? Well, when Miss Merchant filed the motion to disqualify, now the game plan has to change. The game plan I call the deflection. Begins to take place. The deflection is when the district attorney sat down and wrote out. Look at I'm sure the court has. When you look at that video, it's in evidence of her speech at church. She has written out everything and she's reading from it. She chooses to deflect. The court asked earlier, wasn't she really responding to the motion that had been filed against her? Would that she had. Because if she had, she would have looked the members of that church in the face and say, there's been an allegation that I had a romantic relationship with Mr. Wade. And ladies and gentlemen of this congregation, it's true. She didn't do that. She chose to deflect and to do two things that are reprehensible for any lawyer, but particularly for a prosecutor. She chose to pull out the race card and the God card. That's what she did. And she wrote it out. She went on to deflect away from the allegations in the Wade motion. And she said, she's saying, why, in her talk, public discussion with God, why are they only attacking one in reference to Mr. Wade? And then she goes on to say, God, isn't it them playing the race card when they only question one? Now, if she had been truthful with that congregation, truthful with the community, she would have said, I had a relationship with him. Good, bad, forgive me, whatever. That's what she should have said. But she chose to deflect and say them, the reference to them and the others and they. It's obviously a reference to the motion filed by Ms. Merchant. They choose to go after the black man. And she then goes on, again, deflecting away and deflecting to what I call the third rail in American society, choosing somebody on the other side of being a racist. So-and-so is a racist. They're racist. She was the one playing the race card in a way to try to deflect from her own conduct. She goes on to say in discussions with the Lord, God, is it that some will never see a black man as qualified no matter his achievements? Again, the deflection. What is she saying? The listener is not necessarily in that audience in that church. The listener is at Fulton County. The potential jurors who will come into a courtroom and say whether or not they can fairly judge the evidence or judge the defense in this case. She chose to inject race into the minds of the listeners and virtually everybody in this community and literally everybody in this country has reviewed and analyzed her speech that she made in a premeditated way. And in bringing in not only the race card, but also in bringing in the religious matter. This is exactly what Hammonds v. State and our Supreme Court talks about condemning as an inflammatory appeal to the jurors' private religious beliefs. Why would she do that? To deflect. But now, not only is she deflecting, but she is then going forward and in a way telling the community, telling the congregation that God is on her side, not on the side of these people. God, she said, and when she's talking, and she's saying, God, pray for their souls. I, meaning God, qualified you. I qualified your imperfect, flawed self. I see you in every hour. Do my work. As though she's telling the folks in her very, very, very implicit way, injecting into the minds of the jurors, God wants me to win this case. God wants me to prosecute this case. And why is he going, and why are these others going after the black man? Well, the answer is very simple. As we said in our brief, we didn't mention Mr. Cross, the white female, or Mr. Floyd, the white male, because there was absolutely no evidence and is no evidence of a personal romantic relationship with them in which he obtained these benefits. That's the reason why we did not do that. So she goes forward with her with the deflections. That's exactly what she does when she goes forward. And she talks about a planned interviews time and time again with authors of the book, Find Me the Votes, where she's talking about a case that's going to be tried in this courtroom. It's reprehensible.
So in that specific, instance, setting aside the fact that she was willing to go on the record before a case had even reached the jury, what specific statements from that book do you contend cross the line?
Well, for example, she's saying, she goes on to talk about all the calls that she gets from people calling her racial terms. And all the calls are racist. What she's trying to do, and I think there's a reference in there to MAGA people, whatever. In that, what she's really saying is that those people calling me up and making those claims or those horrible racial slurs to me are really people on their side of the fence. That's what she's doing. And there's no reason, Your Honor, ever for a prosecutor to sit down and go forward with this kind of interview. She did it in Find the Votes. But then what really happened here is this hiding of the relationship. Because in hiding the relationship, they have done such a good job. Mr. Wade filed false documents in his divorce case when on May the 23rd, May of 2023, talking about, have you ever had sexual relations with a person during the course of the marriage or including the period of separation? He's still married. He doesn't have a divorce decree, but his answer is none. Then he's asked whether or not on any occasions he's entertained or been entertained by someone, for a woman, a member of the opposite sex, in this case a woman, from the date of the marriage to the present, talking about place and time and all that. What is the answer? None. Why does he do that? He does that because he doesn't want to tell about the relationship that he has with Miss Willis and the benefits that he has gotten and that he gave to her. That's exact. And what these answers are absolutely reprehensible. That a member of the State Bar of Georgia would file these answers that are inaccurate. What does Miss Wade do? Miss Willis do? Miss Willis, on her financial report, on whether or not she has gotten anything of $100 or more in value from a prohibited source. The court asked earlier about what a threshold might be. Well, for the financial report, it's $100. That's it. She doesn't report any of all of the benefits that she received from Mr. Wade. All the trips, all the entertainment, all the 3 nights in the luxury suite in Aruba. All of that, none of that is here. And they say, oh, well, maybe it all balanced out, even though I can't prove it with the cash. Well, that's like saying, did I give the court a Christmas present? Well, maybe I gave the court a Christmas present and the court gave me one back. The court has to fill out a form whether you got a Christmas present from anybody. You say, I got one from Mr. Gillen. You don't say, nah, well, I gave him one back, so it really evens out. They're false reports. And because they're false, what they had to do is they had to say, uh-oh, Miss Merchant has caught us. And so what we're going to do is we're going to get, in our response, we're going to get Mr. Wade to file a false declaration, which he does. His declaration in this case is false. And the evidence showing that that is false as it relates to the timing, and the court asked earlier, why does it matter if the relationship was before or after November 1, 2021? The answer is they think it's important, and frankly, I do too. Because when she's hiring somebody and she's not telling the people who are going to be paying the tab up to $700,000, hey, I just hired my boyfriend who's taking me on trip to the Caribbean and taking me down to Aruba and taking me to California. Hope you don't mind. No disclosure whatsoever, and the money flows off. But because they got caught, they then commit what I think is an additional component of forensic misconduct, and that is fraud on this court. When they filed that affidavit, and now it's been proven, I think, beyond virtually any doubt that the relationship occurred prior to November 1, 2021, and the benefits that were there, and we don't have to run around. And I love we've got all the records showing from Mr. Wade about the payment for these trips, for the cruises, for the flights, all this stuff. What's the only way is they sat around and met together before they testified and came up with their story. What's the only way that they can save themselves? Pay no attention to the records. Pay no attention to the airlines and to the flight.
So we're getting a lot of arguments here and evidentiary hearings and listening to all this. So you guys let me know what you guys think, that what you're hearing here. And it's all sounds pretty good to me. They do need to be disqualified. But now we're going to only seeing one side or hearing one side of this right now. So we're going to have to see what happens. If you guys notice, my camera's been going in and out, and I'm not sure why. I'm having some trouble with my computers, and I was been text messaging or emailing with CyberPower, where I got my computer from, and they're wanting to change some stuff, and that means I'm going to be without a computer, and I'm not doing that. I got things to do, so I'm going to try new cameras. I'm going to see with one of the cameras, with this camera I just bought. So later on, after I get off of here, I'm going to hook up my webcam because I also have a live feed tomorrow for the Michigan caucus, the Iowa caucus, or no, Idaho, and another one for tomorrow. Missouri, I think it is. We got 45 seconds. So, yeah, we got Missouri caucus tomorrow, Idaho, and Michigan caucuses tomorrow. If you want to join in, join in. Well, I'll be on at 8 o'clock with Brendan Statler from the Brendan Statler Show. So if you want to join in, join me. I'll be on here on Rumble, of course, and locals, Twitter, Twitch, or X, and YouTube. I'll be doing all those live for the election results from all the primaries all the way up to general election. So, okay, we got about 8 seconds and they're coming back. So let's listen in. Okay. So they're taking a quick commercial break. Let me know what you guys think. What's going on, and what do you think about what they're saying with the evidence and the testimonies that they've had these past few hearings. I'm just curious to see what the defense has to say when it comes to Wade and Fannie's attorneys. It's going to be a comedy show, I think, and they're going to try to deny everything, all the relationship and everything, but the text show them. But let me know what you guys think when you're hearing it for yourselves. And that's why I'm doing this, so everybody could hear for themselves. But I don't think they have much more time left, because we're already on here for about an hour, almost an hour and a half now. And I don't think they have much more time. So this should get concluded here real soon with that part. I don't know if they'll take a break in between or not, if they're just going to let it play through. And hopefully the judge will come back with something today on this, and hope it's going to be total disqualification of this case, because there is a conflict of interest. They should have withdrew, but no, she wanted to get popular and be the one that says she got Trump, just like Letitia James in New York, the corrupt bitch that she is. So let me know what you guys think in the chat, and we'll continue to watch this here. We got about 20 seconds. And then we're coming back and we'll hear the rest of what this guy had to say. So, okay, let's watch this in about 5 seconds. Oh, depends. We'll have to listen to the state. Yeah, we're getting a lot of commercial breaks here. Wish Fox would quit doing that so we could see what exactly gets going on and hear everything that's going on, because I think this is the last guy that's going to be talking for them. So then we're going to get into the state's arguments. This is obviously the defense arguments. So we'll see what's going on. Let me know what you guys think. I know this is a little boring to listen to, but it's a very important case, and this could throw a lot of wrenches into a few of Trump's indictments over this. And he needs a break right now. So let me know what you guys think. Leave some comments in chat, and hopefully when some of you guys watch this again later, you guys let me know. You guys can leave some comments and let me know what you think about this is going on, because this is all a bogus trial anyways. They're trying to persecute Trump for something that did not happen. He did not try to cause an election interference, because we know who's caused the election interference. It's the states with their pausing of elections results and all of a sudden coming up with miracle ballots for Joe Biden on 2020. Democrats challenge an election every time they lose, every time, and nothing's ever done about it. So I don't want to hear about Trump asking about something in one election. So get over it, you pansy liberals. Okay, we got about 10 seconds and they're going to be coming back. So let's listen in. Okay, you heard that. Now I want to show you. It's about a 3-minute, little less than 3-minute compilation that I put together from the Terrence Bradley hearing part, where his testimony. So I want you to listen to all the times that he recalled or he could not recall something. So listen to this.
I'm going to just go straight to where we left off before. Fani Willis and Nathan Wade were in a romantic relationship, correct?
Correct.
And it began at the time that they were both municipal court judges, correct?
Objection, Your Honor, based on privilege. That would be covered in the attorney-client privilege.
Okay, overruled.
I do not have knowledge of it starting or when it started. I see the message there, but I don't recall. I do see that message, but I do not recall.
You don't recall texting this?
I look back at my text messages through that we've had. I see that message, but I do not recall that. No, ma'am. I cannot answer that. I've said over again that I didn't have any personal information where I could personally say when it started. I've said that time and time again. So I don't know when the relationship started. I don't know how to answer that. So I don't recall. I don't recall any specific dates.
Judge, he doesn't remember much of anything right now, and so I'm trying to create a timeline to hopefully piece this together.
Don't recall, but...
And Judge, I just want for the record, because sometimes the record doesn't reflect where people are looking, and that when I ask a question, Mr. Bradley is looking at Mr. Wade and his lawyer to wait for them to object, and they're clearly interacting somehow.
I do not recall how it came up. Don't recall getting a second email from you now. I don't recall. Do you? I can't recall what. I don't recall him saying that, no.
You don't recall?
No. I do not remember him saying that. No, I don't have any knowledge. I don't recall that. I do not recall at this time. I don't recall. No, I don't recall. I do not recall where I got the information from. I don't recall having any other. I don't recall. I don't recall. But I don't recall. I do not recall a conversation about that. I cannot recall that. I do not recall any dates. I'm telling you, I did not recall. I don't recall, but I have no answer for that.
That's a simple question, Mr. Bradley. You're a lawyer. Did you lie to Miss Merchant when you told her facts about Mr. Wade and Miss Willis's relationship?
Not that I recall. I don't recall. I can't recall whether or not I don't recall. I don't recall if I ever said I don't remember. I could have. I don't know. Funny. I don't recall ever saying that.
Funny how he gets amnesia during all this, don't you think? It's just totally ridiculous that this man, for one, is an attorney. And he changes his testimony up totally from the first time that they had him on the stand to he knew exactly when the relationship started to not knowing a damn thing. So if you're looking for an attorney in Georgia, don't pick him because he's not going to recall anything. Or all of a sudden, when you pay him money, he's going to recall everything. This has been going on for months now, and the sham of a trial needs to stop. All the indictments against Donald Trump needs to stop. It's ridiculous. It should be over with. And everybody involved in this covering up and the false indictments should pay for this. If they're a lawyer, they need to be disbarred and never practice law in this country ever again. If they're not, throw them in jail. Any bit of money that Donald Trump has put out needs to come out of their pockets, not out of our tax money. Make them pay it out of their pockets. Because this is ridiculous and it's a cover up. And there's that bitch in there. So they're back at the courtroom. So let's go here, listen to what's going on. Miss Piggy. Oink, oink. That's Miss Piggy right there. Should have put my thing, Miss Piggy in jail up. Of course. Of course, they're going to go to a break. And we're trying to get this set through, and I want to listen to the lies that are coming out of their mouth. And it's already starting. So we're going to have 2 or 3, maybe 4 of those guys that'll be feeding this bullshit. But still, let me know what you guys are thinking, what's going on here. And I was trying to add some more stuff because they keep showing Fani Willis, and that was just my phone. But I can't add anything else while we're live. So we're talking, we got almost 2 hours now we're on here. And we just started with the state's side, which is already lying. So it's going to get interesting into the next hour and 15 minutes or whatever they have left to see what's going on. But we have a lot of things that Nathan's been proven wrong with. And of course, the phone records and texts and everything of Nathan Wade to her, that proves it all right there. Let's see if this guy brings it up or not. What else do I have on here? And I can't even read that part. But there's also a bill Nathan Wade put in to get paid for White House meetings, 2 of them before Trump was indicted, and he was at the White House during the Biden administration. What was he doing at the White House prior to indicting Trump? And right after these meetings is when they indict him. Don't tell me that they weren't involved. And we got about 10 seconds, and they're going to be coming back. So let's listen in to see what's going on now. I'm on Fox News. It's Miss Piggy again. Has nothing to do with the outcome case.
Email.
Uh, uh, uh. Here we go again. Again, this guy is stuttering all over the place because the judge is proving him wrong. That each case that he has brought up does show an appearance of impropriety, and this guy is stuttering and doesn't know what to say. So I'm not sure. This is still the first guy. I don't know if this is the only one that's going to talk, but he's been at it for quite some time now. So it's hard for me to believe that they don't have somebody else going to talk because this guy's a bumbling fool. He was definitely not the right choice but they're trying to cover their lies that they've been saying the whole time. So maybe this guy's been a good liar in the past and covering up, but he's not doing a good job of it now. So let me know what you guys think. Leave me some comments in the comment section. I know there were a lot of people that has dropped off from watching this because it's definitely a boring thing to watch and listen to that these guys talk, but it's a very important hearing. So please, when you guys watch it, share this video. Don't forget to like and subscribe and follow me on Rumble and YouTube and Locals, and Facebook is under Charlie Brown actually. And X under Country Conservative. And so help me get my reach out a little further. Watch my videos, share them with your friends and family. Get them out there because this election is so important. This is the kind of stuff that we have to stop. So we got about 5 seconds. We're going to get back into it. So let's listen in again. Miss Piggy needs to stay in her seat. Well, it has been shown. They haven't proved that she paid her back. No, they didn't. It was not proven. Fact. Holy shit. Yes, it does. This guy's an idiot. Beyond idiot. Oh my God. He's so full of it. It's unreal. And it was. The judge just shown a conflict. He's repeating himself. Now, if you guys listen to that just now, the judge himself even said there was a conflict of interest because of the money that changed hands. And the state did not prove that she gave him money and paid him back for some or any of the money that he spent on her on trips and gifts and dinners and all that. And the judge just said it himself. That is still a problem because you can't have anything, gifts or anything, as a DA. So this guy just screwed their whole case just by agreeing with the judge that, yes, money changed hands. Well, that screws him right there. He just showed that there was a conflict of interest and there was impropriety for this case. I just don't get it. This is dumbfounding. But we'll talk more after a bit here. But she's screwed. And on top of that, with this, that she admitted that she kept money from her campaign in her house, and she said that herself. You heard it on tape, or you heard it on live TV when she admitted to that. So that's not the only thing that's been going on, and she's paying this Wade that couldn't fight a traffic ticket in court to be a special prosecutor, and paying him hundreds of thousands, almost $500,000 or over $500,000 to be a special prosecutor that he had no right doing. So we're about 25 seconds in left before Fox goes back to the hearing and see how much we're missing and laugh at this guy. So let me know what you guys think in the comment section. We've got about 12 seconds left, so we're going to go back and listen to what this guy has to say. So here we go again. Okay, did I do that right? I'm back. I guess they have nobody else that's going to testify or to argue with this. He's going to be the only one. That's pathetic. Oh, he needs to shut up. This is fun. You haven't been there for a while, but this man is totally screwed. This Fani Willis and Nathan Wade. He's an idiot. All their credibility is shot. They all lied. Annie, Nathan, Bradley, her dad, everybody. In the second one, but in the text messages he did. He's drawing at straws now. For what? Wow. Now we'll put that blame to somebody else. 2, the indictment. Wow. Right. Bullshit. And they did. Wow. Didn't have to. Oh, wow. Because you guys wouldn't let him talk. And he wouldn't say, he said, I do not recall. Get that? Wow. Oh my God. Fox News, they're getting good. Everything when things are getting good, Fox News has to take a break. This guy is totally screwing up. And I'm glad. I'm glad because this should disqualify both of them and the whole office, the district attorney's office. It's just laughable what I'm seeing here. And he's the only one that has a closing argument for Miss Piggy and Wade. And it just dumbfounds me that this guy is that stupid. So there's another attorney that you don't want to hire, and that is Miss Piggy's attorney, because he dumb. He dumb. And I'm not that smart, but I'm not that damn dumb. Or maybe I am, but I don't know. But this is funny as hell to see this guy screwing up so bad. Don't forget to follow me on my Rumble page. We've still got about 57 seconds here at Country Conservative. I'm also on YouTube at Country Conservative 1776 and under Charlie Brown on Facebook if you want to follow me on there, and Country Conservative on X, Twitter, if you want to go on there. But the state's attorney is such an idiot, and of course he's probably part of the Miss Piggy Fani Willis DA office, which they will all be disqualified if this happens. And he is actually pretty much guaranteed to do it, but you never know what the judge is going to come back with, and hopefully this is going to be an easy decision for the judge. So now we've got about 7 seconds, so we're going to listen back in and see what's going on here. So let's go back. Lied that they did not cohabitate. It's full of shit. Blows my mind what's going on. No proof. Oh, get this out of here. No proof. Ooh. No, she said that. She said all that stuff. Nobody asked her about that.
Email. text.
The Michigan State Private. The Michigan State Private. The Michigan State Private. What is going on? I don't know what's going on. If you guys can't hear my audio on my video, let me know, because I'm not sure what's going on here, and you should be hearing it. Because I'm hearing myself in there, so the audio should be working. Let me check this again and see if this happens. And I had this going the first time, and it was working just fine, and I'm not sure what's going on. So let me know if you can hear me and or my audio. So we still got about 30 seconds left before they come back. So if you guys can hear me, please tell me in chat, it's yes or no if you can hear me. And then I'm going to turn the audio back on, or the video back on, here in a second. We got about 19 seconds before they come back from commercial break. So please let me know if you hear me, and see if something's wrong with my video, because I'm having some issues, but we got coming back right now about 4 seconds. So here, let's listen in.
Is that Mr. Bradley was in.
Listening in still out of Fulton County, Georgia, where we are hearing now the prosecution's closing arguments. Earlier today, we were hearing from the defense. Let's keep listening in live.
And that's just false.
Listening in still out of Fulton County,
contain
Georgia,
that.
where we are hearing now the prosecution.
Pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation. If you, as Your Honor, reviews the full chain of text messages, it is clearly Miss Merchant and Mr. Bradley going through what I can describe as nothing else other than a mere fishing expedition between the two of them at first, because it's asked about certain members of the DA's office who would have information as it relates just specifically, for one, Miss Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed in reference in the text messages. All of that was speculation. And you know it was speculation because not a single one of them testified. That's telling. Because if it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture, each one of those people who were subpoenaed would have been called to testify, like District Attorney Willis was, like Mr. Wade was, in order to be confronted and then impeached by Mr. Bradley. You've heard, obviously, about the phone records, and I have a maybe, because whether it comes into the purview of Your Honor as it relates to the determination Your Honor is to make as it relates to the disqualification of the district attorney. You also have the affidavit from the employee who worked at the winery, who confirmed that Ms. Willis did in fact pay in cash up to more than $400. And I understand that this is part of the proffer of the state, but it's important because that is a witness who the state didn't go find. That is a witness who went to CNN in order to confirm what Ms. Willis testified to, further giving her statements credibility and credence before the court. You heard about...
Well, before we move on from that one, other than the foundational concerns, would you have a response to the proffer of the cell phone records?
I have, I'll get to that now. I was going to get to it later, but I have several foundational concerns as it relates to the cell phone records. I don't think I've ever, as Mr. Sadow's motion makes very clear, the state uses cell phone records routinely. And I would agree with that. We use them routinely, but we use them with an expert, and they're always challenged.
Right. So, like I said, in the interest of time, setting aside the foundational concerns.
Oh, I thought you were asking about them.
No. The focusing on the substance of them, assuming that it would be admissible in the guise that he's proffered. Maybe you have that further up, but what's the reaction to that?
So what I would say initially is that due to the fact that they were analyzed by someone who was a non-expert, the analyzation of those cell phone records were not properly peer-reviewed. They were not, it's clear from the state's review that the normal practices that are used to check the use of which kind of data is being used in reference to the two specific dates. I believe it's September 10th and 11th and November 29th and 30th. The affidavit that is used to say that Mr. Wade remains at Ms. Willis's or in the area of Hateville, because again, during the hearing, the address for the Yurdy condo never came out. It was just that it was the Hateville condo. The actual phone number for Mr. Wade was never established. And the documents that were provided to the state that were certified business records did not have a subscriber page. So we have no idea that the number belongs to Mr. Wade. Now, I understand Your Honor wants to look past the foundational issues, and I can appreciate that. But the foundational stuff is very important as it relates to the admissibility of the records.
No doubt about that. But if somewhere how they were able to survive those foundational concerns, do you have any reaction?
Yes, I do, and I will skip forward so I don't. So what's interesting is that the records that were provided they start in January of 2021 and they go, I believe it's to November 30th, I think is what of 2021, it's the span of the records. And you heard from all of the witnesses, including Ms. Yurdy, that Ms. Willis did not move into the Hateville address until April of 2021. That was the testimony from all of the witnesses, April of 2021, and that she lived in her South Fulton home from when she met Mr. Wade in October of 2019 up until when she had to move. And the assertion by defense counsel is that Mr. Wade and Ms. Willis began a relationship right after they met in October of 2019. What's interesting and what's telling is that Mr. Wade's handset doesn't once appear in anywhere near the area of her South Fulton home, but they're dating, but they're in a serious relationship. And if you were to believe what the defense counsel says, that they have been in a relationship from October of 2019 up until she moves in April of 2021. So, a year and a half or so, but he never once enters the area of her home. But they want you to believe that that's a lie, which is why counsel for defense continued to press District Attorney Willis and Mr. Wade as to whether he had ever been to that South Fulton home. Well, this corroborates that that was not a lie, that he had never been to that home. And it's more than suspect if you've been in a relationship, as they claim, for all this time, but never once went to the house. So I think that's telling. What I would also bring to the court's attention in the state's initial review of the records, that from January of 2021 to March of 2021, those times when Ms. Willis did not live again at the Hateville address, she didn't move there until April of 2021, that his handset appears in that area 23 times.
Sure.
Why
How do
she's
you, how
not
do you
living.
reconcile that with this testimony that was alluded to, I think, by opposing counsel, the reasons he gave for being in the area?
Well,
Would those line up to 23 times? I think,
Well,
I didn't
what
give too many reasons for being there, right?
Well, I think that's the point. I would say yes, that is the point. He referenced that that's an area that it was not uncommon for him to be in. And clearly that is the case because Miss Willis didn't live in that area. So again, it's further corroboration as to what Mr. Wade indicated to the court. And after Miss Willis moved into the condo in April of 2021, they appeared 35 times. Now, I want to make clear to the court, both Miss Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Miss Willis and Mr. Wade was that he had never laid his head, was the direct quote, at that condo, which these records don't prove that he laid his head anywhere. If you were to believe the analysis, or if you were to give credence to what the non-expert says as it relates to Mr. Wade's handset in September and November for the 3 to 4 hours that the phone is alleged to have remained, that doesn't disprove anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there. The specific hours of their visits was not something that was pursued during the questioning of both of the parties. So what I would also submit to the court is that if you look at the days as it relates to in September and November, the use, the type of information that is used to make the plots for the longitude and latitude of the handset is data records. It's not voice records. It's not SMS or text messages. It's data records. And it is not uncommon for an expert to testify as it relates specifically to AT&T records that actual data record is unreliable as it relates to the location of the handset due to the type of information that it is, that it's data. It's not the voice and the SMS, which I know, Your Honor, as has been referenced, was a prosecutor not only here in this county, but for the federal government, where this kind of information is commonly used. So in the comments that were made by the court, it was clear that you understood and understand the use of cell phone records as it relates to put somebody in an area, and again, not in a specific location.
That's what
I'd also bring to the court's attention as it relates to the validity of the affidavit and the analysis done by the expert that was hired by Mr. Sadow, is that not once does it reference the fact that AT&T records commonly have duplicate and triplicate entries within the call detail records. That is something that is commonly seen, and that is something that is seen in these records. And that is something that leads to the incorrect number of times that has been alleged that Ms. Willis and Mr. Wade were in communication through text and voicemail. And I'd also submit to the court that number doesn't prove anything again, doesn't prove that anybody's in a relationship.
Oh my God.
It proves that they were in communication with each other. And I think Your Honor can use your own life experience as it relates to people you work with or friends that you're close with, and the number of times that you make calls to any of those people. I can submit to the court that
in under a year.
I have a friend who I have been friends with for 15 years, and she worked in the office previously with me. And based on our professional relationship and our personal relationship, the friendship that we had had and still have, that we talk 30 times a day. So that doesn't mean we're in a relationship. So the assertion that the number of times that Miss Willis and Mr. Wade have spoken to each other, whether it's through text message or phone, it has no validity as it relates to them being in a relationship. What I would submit to the court is that what was shown through all of the evidence was that there's been a true cost to Miss Willis as it relates to her life. that she had additional expenses that she had to endure because of her position, in the sense that she told the court that she had a mortgage, but on top of that mortgage, that in a house she didn't live in anymore, she had to pay for a safe house, that her home was vandalized, and there were racial epithets and sexual bigotry that were spray painted onto her house. The concern of her safety in her life is something that was testified to. And the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence, and the credibility of those statements were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times since all of these instances occurred. The stateful nature of the statements and the falsehoods that, for example, in these text messages that were purposefully leaked to the media as it relates to Miss Willis's daughter, subjecting her position in school, that she flunked out of college, which isn't true, which in fact she has graduated from at HBCU. But what's been leaked to the media is the fact that she flunked out of school and someone other than her father moved her, which again, the validity of which was never shown. And all the while, Ms. Willis, facing these costs, has been able to continue to do the work unrelated to this case, which is shown in the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office. What was shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's, I guess, the relationship that transpired from the relationship between her and Mr. Wade, and that there was absolutely no evidence of a financial benefit that she gained as it relates to the prosecution of this case and the ultimate outcome of the case. Corroboration of all of that is the things that Your Honor is very much aware that she could have, I guess, financially benefited from stretching out the case, for lack of better words, by the special grand jury recommended that 39 individuals be indicted. But through her sifting through the special grand jury's report and all of the evidence with the team that indicted the case, they only went with 19 of the defendants, which had she gone with all 39, based on the defense counsel's assertions, would have given her the opportunity to certainly find these financial gains that are claimed through the allegations of defense counsel. More importantly, why would Ms. Willis repeatedly ask this court to set a trial date as soon as possible if her motive in prosecuting this case was to continue to financially gain as alleged from the prosecution of this case? It doesn't line up. It doesn't make sense. And it doesn't make sense for a reason, because it doesn't exist. More importantly, this office has multiple RICO and as well as large scale cases like this one and much larger. And they also there's a lot of high profile prosecutions. If Ms. Willis's ultimate goal by hiring Mr. Wade was for her financial benefit, then she would put Mr. Wade on every single one of those cases. So she could certainly revel in the riches and lavish lifestyle that has been referred to by defense counsel, which there's been absolutely no evidence of. The evidence was she stayed at a DoubleTree in Napa, a DoubleTree. I don't know that to be a lavish hotel. Most people, when they go to Napa, if they want to lavishly experience Napa, stay at the Ritz-Carlton, the Four Seasons, things of that nature, not a DoubleTree. So the allegations and assertions that Miss Willis was living the lifestyle of the rich and the famous is a joke, an absolute joke. As it relates to what you heard, and the secondary issue is the forensic misconduct. And for lack of better words, what it has to be shown is that the statements that were made here, Ms. Willis, related to the prosecution of the case and ultimately the guilt or innocence of the defendants. And we have none of those statements. There's been no evidence. Nothing has been provided to Your Honor as it relates to Ms. Willis's specific statements made about any of the defendants and in relation to the guilt or innocence of any of the defendants. I forget which defense counsel referenced the fact that she said she had a 95% conviction rate. Well, what Ms. Willis's job is to instill confidence in the community as to how well she is doing as it relates to her constitutional duties. And that was exactly what was done when she referenced that she had a 95% conviction rate from the previous year that she was serving as a district attorney. More importantly, it's been the allegations about race and religion being imputed in her speech, and that those comments were directed at the defendants at this table. And if you listen to the speech, those comments are directed at two elected or political officials. I believe it was Marjorie Taylor Greene and Ms. Bridget Thorne, who is a member of the Fulton County Board of Commissioners here. She's
playing the
All right,
blame
you're listening
game
into
again.
the state's closing arguments in the case to disqualify Fani Willis. We got to take another quick commercial break. We'll be right back with more coverage from Atlanta in 2 minutes.
Okay, once again, they take another break when we're getting good. This guy is a big idiot. There was a financial gain proven that she was financially gained by all the trips. The trips were proven. They admitted to the trips to California, to Aruba, to Florida. And this guy is an idiot. And the reason why she wanted to hurry up trial date was so she could hide this relationship with Wade. That's the whole reason why she asked for a hurry up hearing. So this guy's an idiot. What do you think, Brendan?
I think this should be pretty open and shut, honestly. I don't know how there's much dispute with this case. You know, the argument that they seem to be making throughout this is, you know, when the relationship started. To me, it shouldn't really matter when their relationship started. The only thing that should matter is the fact that they had a relationship. That should show the conflict of interest, regardless of when the relationship started or ended. If it ended at all, shouldn't matter. It's the fact that these two were involved in a romantic relationship, and she appointed him to prosecute this case, despite the fact he didn't prosecute anything more than a parking ticket.
Exactly.
And that they're going on all these lavish vacations together. That's a conflict of interest. They should be removed from this case. The charges against President Trump should be dismissed, because if you determine that they were compromised in this case because of their conflict of interest, how can you say that the charges they put forward were not compromised?
Exactly. So we're going to
Welcome
get
back
back
in
here.
live
They're
now.
back
We're
again.
still listening into the prosecution's closing arguments. It looks as he's stepping away from the podium. Let's keep listening in.
To increase, the most recent instance was the text messages that Your Honor hadn't ruled on their admissibility prior to their release, and it was made clear during the hearings that the ability to get those the full chain was something that they were unable to do, but they figured a way, and the minute they figured a way, they released it, the information to the media simultaneously with turning it over to the state and the court. For all the reasons obviously stated before Your Honor, that this motion should be denied because the legal requirements that are required in order for the district attorney to be disqualified have not been satisfied. The defendants have failed to raise any issue legally or factually to satisfy the legal standard for disqualification. They must show an actual conflict. They've been unable to show that the prosecution of this case was at all a result of political bias, which has been accused, or accusations have been made as well as demonstrated that the prosecution of this case was motivated by any means or any way because of malicious prosecution. And they haven't been able to prove that this case was one of selective prosecution for political benefit or gain. All allegations that have been made during the course of different hearings and the procedures as it relates to this case. What I would leave the court with and how the state started the argument is that courts have been generally unreceptive, if not hostile, to attempts to disqualify prosecutors based on pervasive and institutional conflicts, which makes clear that the burden, that the standard is very, very high that must be met in order for an elected district attorney to be disqualified. And that burden, that standard has not been met. And actual conflict has not been shown. And more importantly, in conjunction with that, there's been absolutely no evidence that the district attorney has benefited financially at all, but benefited financially in conjunction with any outcome, whether it be now or ultimately as it relates to the prosecution of this case. And because of all those reasons, Your Honor, we would respectfully request you deny defense counsel's motion to disqualify the elected district attorney, Ms. Fani Willis.
All right. Thank you, Mr. Body.
Your Honor, I think we have 5 minutes and 44 seconds.
If that's what it says. Mr. Cromwell. Okay. Handing it over. Understood.
Fani Willis exiting the courtroom.
I'm going to do rebuttal, specific rebuttal. One, state somehow makes an argument that we should have asked Mr. Wade questions about his relationship and his communications with Mr. Bradley when they objected over and over and over. And Wade's counsel objected over and over and over, claiming that everything that Bradley was told by Wade was attorney-client privilege. Your Honor made determinations thereafter to Bradley. We didn't get the opportunity to call Mr. Wade back to the stand. So to claim that you can't impeach him because you didn't ask him when they objected to us asking him is obviously a false position to take, as disingenuous as it can be. Now, if the court wants to open it up, we'll be more than happy to call Mr. Wade back to the stand. But as the record stands, there could be no confrontation of Mr. Wade when both his counsel and the state are arguing that it shouldn't be done. Second, received about 2 minutes worth of discussion. The rest of it is all on conflict. Forensic misconduct dealing with the way the state wants you to have is if you don't accuse someone or you don't say that someone's guilty.
Yeah, assuming you can impugn someone's character to the degree that constitutes forensic misconduct. Why is that?
I'm sorry, say that.
Here? Assuming you can impugn someone's character to the degree that it constitutes forensic misconduct. I think that I guess the state's primary position was that they weren't talking about you at the church.
Right. And if you go listen to it and watch it, it starts off by saying, why does Commissioner Bridget Thorne and so many others, and then it refers to they attack him for being black. They attack him, not anyone else, just they attack the black man. They're not talking about Miss Thorne or Marjorie Taylor Greene. They're talking about us. And you know how everybody knows that? Because not a single story from the media reported anything other than Fani Willis accused the defense and defendants of being racist. Now, here's the common sense part of this. If you follow the state's position on forensic misconduct, Fani Willis could all day long talk about race. She could say the defendants, I'm not saying they're guilty or not guilty, but they're racist. They're racist. They're racist. And according to the state's position on forensic misconduct, that wouldn't be a problem. Obviously, that makes no sense whatsoever. The issue here that we've dealt with on forensic misconduct is not simply the church speech. It's why she did it, how she did it, calculated, and all the other things that we talked about with the testimony of Wade and Willis in this case. Let's go to the relationship issues and the cell phones briefly. No one knew that there was a relationship between Wade and Willis. according to Wade and Willis. Not a soul was ever told that they were dating or that there was an intimate relationship, ever. They concealed it from all parties, from Daddy. Daddy didn't even know they had a relationship. Suggest that somehow in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hapeville. They didn't meet anywhere that would allow the public to see them. That's the reason why they were meeting at Yertes, because no one else was ever there. Remember the testimony? Who else was there besides Mr. Wade and Miss Willis? Both of them agreed. No one ever went there except them. They didn't go to where Daddy was in Miss Willis's house because Daddy was there and Daddy would know. No other prosecutors knew. No one knows except who? The one person that knew was Bradley and Yerty. Yerty was the best friend at that time of Miss Willis, and Bradley was the partner of Wade. Now, the only way that Bradley can walk away from I have very little time, so I'll skip that. Let's go to something. Motive. That's an issue. Whose motive in this case is the strongest? Fani Willis, Nathan Wade. Because if they testify truthfully on every point, what happens if the relationship started before November 1st? They get disqualified. Who has the best motive of anyone to lie? They do. Who has the most at stake to lie? They do. Who wants to stay on this case for whatever the financial reason may be? They do.
And all right. Thank you, Mr. Saino. There it is. All right. Thank you, everybody. I think it's been very much made clear by the argument and the made today is that there are several legal issues to sort through, several factual determinations that I have to make. And those aren't ones I can make at this moment. And so I will be taking the time to make sure that I give this case the full consideration it's due. I hope to have an answer for everyone within the next 2 weeks. Until that point, if there are any other issues that come up, council can reach out and we'll have an order posted on the docket. Thank you all. We're off the record.
Okay, now you just heard from the judge saying that he hopes to have a decision done in the next couple of weeks. So we'll see what happens. But you guys let me know what you think with everything that you heard today. And if you have to, go back and replay my videos. And this will be posted as soon as we get off of here. But you let me know what you guys think. I think they should be disqualified. And we're going to see what happens. So hopefully we can, because I know he said he's got a couple homicide trials that he has to do, and they've already got scheduled. So, and he just said in a couple of weeks. So please let me know what you guys think. Also, I'm going to be live tomorrow with Brendan from the Brendan Statler Show for the results from Michigan caucus, Idaho caucus, and Missouri caucus. And we'll be going from 8 to 10 for that because of the time zone difference. So if you guys want to join in, please check us out tomorrow at 8 o'clock. We'll be live on all the platforms, Twitter, Facebook, everything. So please join in. And I thank you for signing in today. And thank you for being part of the Truth in Politics. As we sign off, remember that democracy thrives when the citizens engage, stay curious, stay vigilant, keep the conversation alive. Until next time, this has been the Country Conservative. I'm Charlie.
And I'm Brendan Statler from the Brendan Statler Show. Thank you all for watching.
Talk to you later.